In this lecture, I want to look at the principles of direct effect and supremacy. The principle of direct effect requires that the individuals of member states are given rights, and that these rights are enforceable before national courts. And that in itself is very significant, because it means that all the courts of all the member states are effectively EU law courts. So you shouldn't think just of the Court of Justice and the Court of First Instance as being the only EU courts. They sit at the apex of this EU legal system, and all courts in all member states enforce EU law. Now, the principle starts with the case of Van Gent and Loos, which is a case from the early 1960s, a Dutch case, which was based on what was then Article 12 of the EC Treaty, now Article 25. And a Dutch company took a Dutch public body to court because they'd been charged for bringing imports in from another member state into the Netherlands, and they thought that this was contrary to what is now Article 25 of the treaty, and they sought to rely on this treaty right before a Dutch court. And the Dutch authorities argued that they weren't able to do this because there's a provision under an international treaty they couldn't do it. But the Court of Justice, when it was referred to the Court of Justice, said that the company could. And that's what we call a vertical enforcement. When an individual is enforcing a provision of EU law against a public body, that's the so-called vertical enforcement. And as I say, we need to chart the historical development of this principle, and it was a negative obligation in Van Gent and Loos, because the member states had to refrain from imposing customs duties or charges having an equivalent effect on imports. So the principle was extended by the case of Lutiger, where it was extended to positive obligations as well. And in the case of Dufresne and Sabina number 2, the three Dufresne cases, we're going to Dufresne number 2, it was extended to horizontal effect. Now, in the case of Dufresne 2, you had what is now Article 141 of the treaty, which provides that men and women shall receive equal pay for equal work. And Dufresne worked for the Belgian national airline Sabina, a company being an individual in the eyes of the law. She sought to rely on Article 141 against them because stewardesses were paid less than stewards for carrying out exactly the same work. Article 141 provides for equal pay for equal work. Sabina said she couldn't rely on it against them because the wording of Article 141 is addressed to member states. Said, well, we're a company, we're an individual, we're not a public body, you can't rely on it against us, you can't rely on these treaty rights horizontally, one individual against another individual, but it was referred to the Court of Justice and it was found that she could rely on it horizontally. So far we've been looking at treaty articles. We've seen in Van Gent and Loos they can be enforced vertically by an individual against a public body. We've seen in Dufresne 2 they can be enforced horizontally by one individual against another individual. Now I want to move on to the other so-called twin pillar of the EU's legal system, and that's the principle of primacy, also known as the principle of supremacy, and this provides that wherever EU law and national law conflict, EU law will prevail. It started with the case of Koster and Enel way back in 1964, and the reasoning of the Court of Justice was that what is now known as the European Union is a sovereign body, albeit in limited areas. So as it has limited sovereignty, it is sovereign in those areas, so its law will prevail over conflicting national law. There's something of a paucity of reasoning behind the Court of Justice in Koster and Enel. They said, for reasons of schematic interpretation, this idea was inherent in the scheme of the treaty. They said, a teleological interpretation, what are the aims of the European Union as it's to ever increase European Union, that this would move the process of European integration on a bit, so they must do that. And then they said that the rights under the EU treaty would be conditional unless you read in a principle of supremacy. But the only two words they could point to in the EC treaty itself are now what is Article 249, and that says that regulations shall be directly applicable. So at present you will not see the principle of primacy or the principle of supremacy written into the EC treaty. If the Treaty of Lisbon comes into force, it'll be a declaration annexed to the treaty, and no one's quite sure what the legal status of declarations are, although many important matters have been dealt with by declaration, but it's not to date had legislative form. It's only ever been a case law principle of the European Court of Justice.